Many major brands have gotten dragged into years-long legal disputes to protect their trademarks. And to make things worse, the Chinese court system won't necessarily side with the established brands. Sometimes the real brands are even forced to apologize and pay millions of dollars in compensation to their copycats. That's all made possible by a practice known as trademark squatting.
Bro.
Hi, and welcome to the first video in our Chinese trademark series. This series of videos is going to examine some of the challenges, hurdles, and advantages of seeking Chinese trademark protection in China. My name is Daniel Finn, a Chinese law attorney with over 10 years of experience assisting Western designers, entrepreneurs, and inventors protect their intellectual property in China. The topic of today's video is a problem we face regularly on behalf of our clients, and a problem that only seems to be getting worse in recent times. That is trademark squatting. In order to properly understand what trademark squatting is and why it's a problem for you and your business, we first have to have a good baseline understanding of what a trademark is. A trademark is a designation of your goods or services that sets you apart from your competitors. It can be words, a slogan, an icon or logo, or a combination. But the purpose of a trademark is always the same. It sets you apart from your competitors. Trademarks are crucial for SEO, building a brand, and are a requirement on many platforms, including Amazon. But what practically does a trademark do? In this hypothetical example, we have a new client with a new product, a dog squeaky toy that he's going to sell under the brand name Pup Palace. He's designed a logo to go along with his new brand name, and he's registered them both in the US. This means that this client now has exclusive rights to sell products under the Pup Palace brand name or under the new Pup Palace logo. If any of his competitors try and use the words Pup Palace or a similar logo to his, he'll be able to prevent them based on his trademark rights. But further than that, trademark protection extends to similar goods. So a range of other competitors using similar brand names will also be prevented. This is the advantage of trademarks. It gives you exclusive property rights over your intellectual property, and you can exclude all other competitors from using them. So given this hypothetical client already has his US trademark and has no intentions of selling his product in China, why would he need to consider a Chinese trademark? One very obvious reason is that a Chinese trademark could be used to prevent Chinese manufacturers from selling similar products on platforms such as AliExpress. But there's a more pressing issue when it comes to filing Chinese trademarks over new brand names, and that's Chinese trademark squatting. In order to understand what trademark squatting is, we need to understand the manufacturing process. The situation usually is one of our clients has come up with a great new idea for a product and has sought out manufacturers who he or she believes can make the product at the required price and to the required quality. To this point, our clients can rely on documents such as NNN agreements to protect their intellectual property. However, once manufacturing begins, the manufacturer, its employees or agents, or even third parties may notice that your product is doing well on online marketplaces and will then register your trademark in China before you have the opportunity to do so. At this point, it's too late. The trademark squatter can then use your trademark to prevent you from exporting your goods, to seek license fees from you, or even seek damages in Chinese courts. The outcome is nearly always the same. Clients come to us at this late stage and ask us to assist with negotiations for licensing or even the purchase of their own trademark. Often these trademark license fees or purchases run to tens of thousands or even hundreds of thousands of dollars depending on the product. So it's a really pressing concern and one that every entrepreneur should think about before they begin manufacturing in China. Let's look at a recent concrete example of one of our clients. This client was seeing a lot of success with their uniquely branded product in an established category. After several months of very successfully selling his product, he noticed a competitor appear on the market which replicated his branding almost in its entirety. This client had not applied for their Chinese trademark, and thus came to us at this late stage and asked us if we could assist him to apply for his Chinese trademark and then seek to shut down his competitor. The problem was that as we looked into his trademark, we noticed it had already been registered by a small Shenzhen-based company that was totally unrelated to our client or his manufacturer. As we looked deeper, we saw more and more applications in similar product categories for other Western businesses. Some of these may be legitimate, but we suspect that the majority are trademark squatting events from a professional trademark squatting outfit. In the end, our client's manufacturer was connected to a company that registered 6 trademarks, including the trademark of his new competitor. As we traced our way through related companies and shareholders, we found another 250 applications for trademarks of Western businesses through this one trademark squatting venture. Trademark squatting on an industrial scale. But of course, the question arises, is this unusual? Is this a unique case? In preparation for this video, I decided to do a search of Amazon for dog squeaky toys and search the Chinese trademark database for the top couple of dozen listings. You can see as I work through the searches here, nearly every single product on the front page of the Amazon listings for this particular product category are registered to Chinese companies. Again, some of these registrations may be valid, but what we suspect is that professional trademark squatting outfits are fully aware of the importance of Amazon and now regularly use Amazon page listings to register trademarks over products which they know are already successful. So that all sounds very dire, and the problem is serious. When we look at our internal statistics, this problem has increased year on year for the past 4 years. We now regularly even have quite small clients come to us experiencing problems with Chinese trademark squatting and a range of other IP issues. The good news, of course, is that the problem is easily solvable. If you file your trademark first, you own the trademark in China. There are no ifs, ands, or buts. It is 100% protection against trademark squatting and is a cost-effective solution. Some years ago, when we discussed Chinese trademarks with our clients, we used to advise that they should take the matter seriously and, budget permitting, apply for their Chinese trademark before their product launch. That is no longer our advice. Trademark squatting has become such a consistent, widespread, and potentially damaging issue that we now tell clients that they should apply for their Chinese trademark at the earliest possible opportunity, certainly before launching their product, and ideally before revealing their product branding to their manufacturer. In this way, they can ensure that there is no opportunity for trademark squatting in China and that they will have exclusive proprietary rights over their brand names, logos, and ultimately product that they manufacture in China. If you have any questions or you'd like to discuss your business with one of our lawyers, please use the booking link in the description. If you have any other questions, comments, or have a topic you wish that we discuss, drop it in the comments and we'll take a look. As we said, we're hoping this will expand to a series of informational videos, so we're looking for your feedback, both on topics and the way the presentation of these videos is done. We hope this was helpful, not too scary, and we look forward to speaking to you either in a free consultation or in the next video. Have a good one.